Welcome back, everyone, to MIBCC 2019. I'm so sorry about the technical difficulties that we had earlier. Saul K will have his presentation tomorrow at 9 a.m. Central. So please tune in, and hopefully my mic is working now. I'm sorry about that. If you can give me a thumbs up on the chat to let me know that you can hear me, that would be great. I would love to give Saul a proper introduction tomorrow, because he really has done a lot of incredible work in the cannabis industry. And so I know everyone is looking forward to that. So now I'm going to introduce to you Luke Zimmerman. He is the founder of the law office of Luke S. Zimmerman, APC. In 2013, he started working with clients in the cannabis industry on a variety of intellectual property issues. The focus of Luke's practice is assisting clients with trademark, copyright, and trade secret matters. Luke is proud to say he registered the first state trademark for cannabis goods in California. So that is very impressive.
Hello, everyone. My name is Luke Zimmerman. Thank you for attending the MIBCC. I am an attorney out of San Francisco, California, and I am going to be speaking with you about intellectual property issues in the cannabis industry. I have had my own law firm for about 5.5 years. The focus of my practice has always been intellectual property issues in the cannabis space. Primarily, I work with trademarks, which have exploded in the last 5 years as they relate to cannabis goods and services. And my hope for today is that you are able to identify 4 different kinds of intellectual property by the end of this lecture. I want to remind you that this is not legal advice. I have not created an attorney-client relationship with you by giving this lecture. And in the case that you do need legal assistance, I encourage you to seek it sooner than later, as a lot of intellectual property issues are not easy to work backwards from. So if you find out you already have a problem, oftentimes it's very hard to correct. So laying a solid foundation is always a good start. So the topics that we're going to be discussing today are a quick overview of advice for startup companies in the cannabis space and how they should handle preparation for filing intellectual property protection. And then we'll be covering copyrights, trademarks, patents, and appellation of origin, all as they relate to cannabis. Considerations for cannabis startup companies are: ask yourself, what is the nature of your business? Then ask yourself, are there any types of intellectual property that relate to this nature? If there are these types of intellectual property that you can file protection for early, or is there something that has a timeline that you have to file at a specific time? You should consider if part of your business plan is going to be licensing that intellectual property to possibly a third party to generate revenue. You also would want to consider seeking legal representation to assist you with laying out a strategy on how to protect that intellectual property and to cover any maybe unforeseen issues that might arise. The different types of intellectual property we're going to be discussing are copyright, trademark, patent, and appellation of origin. I feel like most people are familiar with copyright and trademark just because they've seen the C with a circle or they've seen the R with a circle. When I'm lecturing about these today, I'm going to initially be lecturing about how these types of intellectual property are applied in the United States. Then for each one of these, I'll also have a slide that indicates how they are addressed in Mexico. I am not a licensed attorney in Mexico, so there probably are some subtle differences that will need to be addressed. So if you are working with protecting any of these types of intellectual property, I strongly recommend you seek legal assistance early. So what is a copyright? Copyrights and copyright protection is for artistic works that are fixed in a tangible medium. Think about sculptures, think about paintings, movies, books. Copyright can have both common law and federal protection. What that means is, by the nature of the artistic work being created and published, you immediately have common law protection. Having federal protection or registering it with the Federal Copyright Agency, the benefit that is granted there is if someone infringes upon your artistic work or uses it without your permission, you have the opportunity then to take legal action on infringement. The length of time for copyrighted works varies country by country, but in the United States, it's life of the author plus 70 years. I believe it is the same with Mexico as well. Here are some examples of how copyright is being used in the cannabis industry. Anything from movies that deal with cannabis as a theme, to the second image is a mosaic made by Cliff Maynard, who's an artist out of Washington State in the United States. And if you can see the mosaic, how there's a different gradation of color, those are actually all old rolling papers from joints. And what Cliff does is cuts up old joints and then uses the different burnt paper to make these mosaics. You're able to find his work if you do a web search for Cliff Maynard, you'll be able to find his work. Then the painting on the right is by an artist named Kathy Lee, who's out of San Diego, California, who makes a multitude of paintings that deal with cannabis themes. If you can see over my shoulder, there's a picture of Bob Marley smoking a joint. That is actually a picture from Kathy Lee as well. There is a movement going on in the United States that I don't know if it's a phenomenon in Mexico, but there is a renaissance of glass artwork being created and glass pipes. So glass pipes have traditionally been used to consume cannabis, and there is a multi-million-dollar industry for this in the United States, and it's moving into Europe as well, and I know there's a little bit of activity in Australia. I'm not sure what's going on in Mexico. Would love to learn more about it, so if anyone watching this has some knowledge, please feel free to reach out to me after this. But one of the aspects of copyright law is, because it's for artistic works fixed in a tangible medium, artistic works that have function, the functional aspect of the work does not actually qualify for copyright protection. So the question I have is, would this pipe, which definitely has a colorful artistic expression of a wigwag, would that qualify for copyright protection? It's kind of a novel question that is coming up due to the cannabis industry. The underlying form of the pipe as a Sherlock piece likely would not qualify for copyright protection, but potentially the color expression on the outside would. These are some additional examples of different cannabis pipes that very much would qualify for copyright protection. The top piece is a pirate ship that has about 14 smokable pieces, I believe, in total. It was made by Ryan Harris, Lacey St. George, and Joe O'Connell. The piece originally retailed for $50,000 and is currently being housed at a Illusion Smoke Shop in Denver, Colorado. And the last I heard, they were retailing it for about $250,000. The bottom piece is a collaboration between Banjo, Snick, Tyson Petzler, and Tristan Hodges, which is titled Freya. Banjo has been making a line of pieces that kind of have a similar shape and form, but this piece is also being offered at $250,000, which, if you're interested in learning more about the glass pipe industry, there's a wonderful movie made by Marble Slinger. It's published in 2011, called Degenerate Art, The Art and Culture of Glass Pipes. I think you could probably find this on YouTube. I know for a period of time it was on Netflix, but I'm not sure if it's available anymore. This is also the art as an art form. If you infringe upon someone else's copyright, you can end up in a copyright infringement lawsuit. And this is what occurred for one glassblower out of Oregon who was making what were called Dabbuccino rigs, or water pipes, with a company called Hitman Pipes. And the reason that these Hitman and this Oregon glass artist ended up in a lawsuit was because they were creating glass pipes that were almost exact replicas of Starbucks cups, all the way down to using the similar green straw as a downstem. And they also were including a variation of the logo for Starbucks on the pipe, and it wasn't exact, but it was similar enough that you could see where the inspiration for it was. And so the Starbucks logo is a trademark, but also had been registered as a copyright, as an artistic expression. The two entities were sued. Hitman was sued, and the glassblower was sued. Now, the glassblower didn't show up for court, so there was a default judgment entered because he did not respond to the summons, but the damages were allotted at $300,000. So there are lawsuits that are starting in the cannabis space based around copyright infringement. So if you are an artistic creative and you're creating content, or you're creating something that has artistic expression, I strongly recommend you consider doing a registration with your federal agency. And that would be the National Institution, I'm going to horribly butcher this, Instituto Nacional del Derecho de Autor. The link for that office is below. The standard for filing a copyright in Mexico is actually pretty similar to the United States. The reason for this is Mexico is a signatory to the Berne Convention, which covers copyright standards internationally. Mexico is also a member of the WTO, which has the TRIPS agreement, which also is international harmonization for intellectual property standards. But you need to have authorship of an original work in a fixed tangible medium. Registration is not compulsory, but much like in the United States, in order to follow up on an infringement claim, there needs to be a federal registration. Next up, we'll talk about trademarks. This is an area, patents are becoming more popular, but trademarks are probably the largest area of intellectual property that have exploded since we move towards legalization in the United States, or we have legalization in Canada. Everyone's creating a brand, and let alone branded products. So a trademark functions as, it's a word, phrase, symbol, or design that identifies the source of origin for a goods or service. So think about, if you look at a trademark, you should be able to follow that back to the company that provided the good, or made the good, or provided the service. In the United States, there's both common law, state, and federal protection. With the United States has a harder time accessing the international registrations due to our Schedule I status of cannabis as a Schedule I narcotic in the United States. But we do allow for ancillary registrations with the United States Patent and Trademark Office, or the USPTO, but we cannot file at the federal level directly on cannabis or cannabis services. The following trademarks you might not be familiar with, but you might recognize some of them. All of these marks have either state or federal registration, trademark protection in the United States. There are, what I like to ask people at this point is if they see a theme, because trademarks also function, the stronger or more distinct they are, the easier they are to protect. And there are a few trends going on in the cannabis industry that are problematic for when you're picking a trademark. Specifically, the repetitive use of leaves, green, and certain words, be it emerald, verde, green, dank kush, smoke, all of these, because they're regularly used words in the industry, it oftentimes works against a company for the distinctiveness of their trademark. This is an issue that I deal with quite often with my clients, is trying to find something that is really distinct. The way that trademarks are identified are on a spectrum, with on the right being generic and descriptive, then suggestive, then arbitrary, then fanciful. If the trademark is generic or descriptive, it arguably does not qualify for trademark protection and doesn't necessarily even function as a trademark. Um, the examples below, so, and I'll just do it for one good. If I am making a coffee product and I call the coffee product coffee, that is generic. It is what it is. It doesn't qualify for trademark protection. If I call it good coffee, that's descriptive. Also does not qualify as trademark protection. If I call it Moonglow coffee, it's suggestive. You understand that it's still a coffee product, but by adding Moonglow, I'm kind of spicing it up a little bit. Arbitrary would be calling it motor oil, because motor oil is something else that exists, but I'm using the concept of motor oil overlaid onto coffee, so it's an arbitrary application. One of the most famous arbitrary marks is Apple Computers. Prior to the work that Apple Computers did in their branding and marketing, if I said I was going to go buy an apple, there was a presumption I was probably buying a piece of fruit. But in today's day and age, if I say I'm going to go buy an apple, it's kind of a question of how much money I have in my pocket and what product I'm really trying to buy. And then fanciful would be zazzablaz. And it is a word that I just made up. It has no real meaning that exists in the world as of right now. But if I started creating a product under zazzablaz and marketing it, that good faith and marketing association that I'm creating, that makes for very strong trademark. So if you're considering creating a trademark, try to be in the arbitrary or in the fanciful range. Those make the strongest trademarks. The problem with the descriptiveness in the cannabis industry is, and I don't know if this is going to be an issue in Mexico, but in the United States, the repetitive use of the word canna, so many trademarks use the word canna that it almost becomes hard to distinguish where the goods and services are really coming from, because there are so many uses of the word canna. And because canna is being used to describe at times goods that have cannabis in it, you're moving closer to just actually being descriptive and not really functioning as a trademark. So that's something to consider when you're picking your name. Trademark infringement is becoming more and more common. Luckily, I do not see this as much in the last year or two as I did a few years ago. But trademark infringement is when you use the exact or similar trademark of another company. And the legal definition of this will vary from jurisdiction to jurisdiction. So the definition of infringement in Mexico is very likely different than what it is in the United States. And actually, infringement in the United States can be different from state to state. But if you are planning on creating a branded product or a brand, and your idea is, hey, there's this existing company that I have an association with, and if I do what I refer to as weedify or mix it up and think that by adding a cannabis feel to it, you're creating something unique and new, you're probably not. You're probably running the risk of actually infringing on someone else's existing trademark. This example, the Reese's or Hashies, was actually done for a variety of different candy products. And this was pretty clear-cut infringement. This also created an issue where it created a public risk because these candies were familiar to children. There's no reason why a child would be discerning in being able to differentiate between what was an infused cannabis product and what wasn't. So this also created a risk for the public and also for the industry, because there was a number of articles written about how the cannabis industry was target marketing towards children or was creating this unneeded risk. So I advise clients, do not, when you're creating your trademark, do not pull on existing concepts or existing trademarks. You're only going to find yourself in a bad situation if you do. There recently has been some interesting trademark claims or disputes in the United States. If you're familiar with the cultivars Gorilla Glue number 4 and Girl Scout cookies, There is a product called Gorilla Glue in the United States, and the company that owns that trademark actually ended up sending cease and desist letters to the cultivators who claimed they owned the cultivar and claimed they owned the trademark for Gorilla Glue number 4. There is a concept called dilution or disparagement, where if you are using another company's trademark in such a way that it's actually bringing harm or devaluing their trademark, there are grounds beyond infringement to make a legal claim about why that use needs to stop. The Girl Scouts of America were not happy with the cultivar use or the name of Girl Scout cookies as a cannabis cultivar, and they actually issued 2 cease and desist letters for dispensaries in California, one in Los Angeles and one in San Francisco, and they took it very seriously, to the tune where there was a follow-up cease and desist letter sent to the dispensary in Oakland, California, because there was still some mention of the cultivar Girl Scout cookies. So this is something to be aware of. Do not really try to avoid using any trademarks that already exist or are famous or popular. Infringement lawsuits are actually occurring just between cannabis brands. In the United States, because we have the Schedule 1 status, which prohibits us from registering trademarks with the USPTO, what has occurred is there are trademark offices in every state. So you will have cannabis companies register their trademarks, and some states are allowing cannabis registration. So I can register cannabis as a trademark in California. It can also be done in Washington. Because it's done at the state level, you only have protection for the state you're registering in. So if I register in California and someone else registers the identical mark in Washington state, I do not have grounds in California to bring a legal claim against the registration in Washington, because it's only registered at the state level. If it was registered at the federal level through the USPTO, then I would have national protection. So this has been an issue as different states legalize in the United States. There are companies that are registering in every state where legalization has occurred, where the trademark office allows for cannabis goods and service registrations. But this has created kind of a broken up who owns what effect in what states. I don't think there are the equivalent of state registrations in Mexico, so I don't know if this will be as much of an issue, but this is one of the things we're dealing with in the United States. There is a company that I checked. I do not believe they have a Mexico trademark registration. This is the registration that they have in the United States, and it is this company called Bedrocan. They are worth looking into. They are originally a Dutch company, and they, from my understanding, so they're a Dutch company. They then set up a medical program in Canada, medical cannabis program, and they petitioned the Dutch government and the Canadian government to allow the transfer of live cannabis clones from the Netherlands to Canada, and it was granted. And from my understanding, they're one of the first companies to have a legal international exchange of live cannabis plants. And subsequently, after, I think it was about a year later, they actually brought dried cannabis flower over from the Netherlands to Canada. So they're kind of a fascinating company. They also, as I said, so this is a registration in the United States. I had mentioned that there is not, we can't register directly on cannabis goods and services. So Bedrocan registered in Class 5 with a very broad explanation of what this is. It's clearly a medical good, but they kind of watered down the explanation, which allowed them to get a registration. Whereas this is the registration for Bedrocan in Israel. And if you can look down at the bottom around the number 511, the registration is for cannabis products, including cannabis and hash for medical use, narcotics for medical use. This is the registration in Canada, which shows that it's for cannabis, hash for medical use, cannabis products as medicine, cannabis seeds, cannabis plants, and also the service of breeding, growing, and processing cannabis. So I use these to illustrate that in different countries there is different types of trademark registrations that are allowed for cannabis goods and services. Um, that if you are going to create a cannabis brand and you're considering being operational in a few different countries, you might want to look into the other countries' trademark laws because you might have more success registering the trademark in those countries if the countries have allowed or permitted for the registration of cannabis trademarks. I want to talk to you about the issue of strain versus cultivar, and if you will notice, I really have not said the word strain yet in this presentation, and there's a reason for this. In the United States, the word strain has become incredibly popular for about how to describe different types of cannabis and different versions of the cannabis plant. The problem with this is that strain really does not have any, it's not an appropriate term in botany or in horticulture. It is just a word that was popularized by the subculture of the cannabis community. And so where it has been assimilated into the vernacular, it's not really an appropriate way to talk about a plant. Strain is actually more appropriate for discussing or explaining viruses, whereas a cultivar is well used in horticultural terms as a horticultural term, and it's used to explain a plant that is cultivated for a specific purpose, and those purposes usually have unique expression, be it smell, color, shape, and so really all of these strains in the cannabis industry are, in my opinion, different cultivars. And where it seems like I might be focusing in on the difference of a word where who really cares, at the end of the day, the name kind of, it still works. There's a reason for this, and that is because of the Trademark Manual of Examining Procedures, Rule 1202.12, which deals with varietal and cultivar names. And the reason this is important is because cultivars in the United States and in Canada, I couldn't figure out, from research, I couldn't figure out if this is appropriate for Mexico or not, but for at least the United States and Canada, cultivar names of plants do not function as trademarks for the purpose because it is a descriptive way of talking about the plant. If the plant's name is Honeycrisp Apple, then you can't use it as a trademark also because it is merely a descriptive aspect of the plant. This is well-tested law in fruits and roses and different ornamental flowers. So I think this is going to be a large issue for the cannabis industry on the horizon. I've started to see trademark applications for hemp-related goods in the United States where, as part of the review process, there is a cultivar search being done. So I'm curious about what this will be and how this will impact some of the United States cannabis brands that are really trying to focus on cultivar names as a trademark. I think that's going to be an issue in the future. If you are creating original cultivars for the cannabis plant, Bedrocan, which was in a few slides before, has done a really creative way of naming their cultivars. And I think that their cultivars, and actually these were more trademarks than cultivars because, so if you look at the different names, Bedronol, Bedropure, Bedroica, Bedrocan, Bedrolite, they're all kind of variations of the Bedrocan trademark, kind of like Coke, Cherry Coke, Coke Light, Coke Clear. And I think that there is a benefit to this because it's going to make protecting their trademarks a little bit easier. And the reason that these are trademarks and not cultivar names is because we'll say Bedroica is being used on a indica cultivar but Bedrocan isn't telling you what that cultivar is. They're just telling you the cannabinoid profile that makes up Bedroica. So there is room to have trademarks used in relationship to cannabis. There's just kind of a process that has to be done, and they cannot function as a cultivar. So if you're in this space, and I can understand that this might be confusing, definitely speak with an attorney who has a knowledge about plants. That's really where I've found this to be most beneficial. Trademarks in Mexico. Trademarks registration runs through the Mexican Institute of Industrial Property, the IMPI. What qualifies as a trademark? A word, logo, slogan. They recently have admitted trade dress, or what's like packaging for products that are really distinct. The grounds for refusal are similar to the United States, especially for descriptive or indicative marks. There are a lot of similarities between the United States and Mexico and how a review for a trademark is done. I know Mexico allows a little bit more time on the back end if a registration occurs. I think it can be challenged for up to 3 years after the registration. So I would encourage you, if you're considering creating a trademark in the cannabis space, do a search first. Look at the existing trademarks that are registered in Mexico to see if they're going to be conflicting with the idea that you have. And then as a secondary step, I would probably go to the WIPO brand database, which is a publicly accessible search engine through the World Intellectual Property Organization. And I would do some searches through there to see if anyone else internationally is using the trademark. So there's what's called the NICE classification system for trademarks, and all goods and services can be filed into one of 45 different classes. The NICE classification system is an international classification system used to harmonize identification of goods and services for all signatories to the WTO agreement. And actually it predates the WTO agreement. But what's unique is currently the NICE classification system does not have any proper identification classes for cannabis goods and services. The closest it has is for hemp, but only as it relates to textiles, hemp rope, and fabric. From my understanding, starting in January of 2020, the NICE classification system for the first time will include medical cannabis in class 5, which I see as a massive shift, because internationally, countries that have already allowed for federal trademark registration are already using classes. Or in California, I file in different classes all the time, where the Canadian Intellectual Property Organization, or CIPO, at the beginning of 2019 actually created their own, or they had their own manual, but they identified the different appropriate classes for cannabis registration. So I looked, and as far as I know, Mexico has not amended their manual or their identification system. It's still harmonized with the NICE classification system. But if you're looking for ideas of how to register cannabis trademarks, I would probably look at the Canadian Intellectual Property Organization at their manual, because the classes that they've used, I believe, will end up being the classes that are used internationally. So that's something to pay attention to. Also, this is something that working with an experienced trademark attorney would be in your benefit. There's some interesting statistics that I pulled from the World Intellectual Property Organization brand database, and they're pretty current. The search was done on 9/14/2019, and what this shows me is, because when you register a trademark, you have to do a description of goods and services, and the goods and services descriptions that use the word cannabis versus the word marijuana, it's pretty telling. And in Canada, you can see about a 2,000 application difference between the use of the word marijuana and cannabis. The United States, which I thought this was going to be higher, but you can see a clear separation moving away from the word marijuana. I thought it was very telling that in Mexico, for the amount of trademark registrations there are, or applications filed with the word cannabis, there's 478. There's only been 4 with the word marijuana that I could find. So I think this shows that as the cannabis industry develops internationally, there will be a slow move to the international consensus that cannabis is more of the appropriate word for describing cannabis goods and services and not marijuana goods and services. Now we're going to move on to patents. A patent, so whereas a copyright was an artistic work, a trademark was used to identify the source of origin of a good or service. A patent is for protecting ideas or an invention, a method, a procedure. A patent registration in the United States still occurs with the USPTO. That's the P in PTO. General range of protection is 20 to 25 years, depending on the type of patent that is filed. And patent protection only is protected in the country that it is filed. So if I file a patent in the United States, that would not give me patent protection in Mexico. There are 3 types of patents in the United States: utility patent, design patent, and plant patents. The utility patent is the most broad-ranging. Can be used for, as I mentioned, methods, procedures, mechanical inventions. A design patent is much more for, if you think of the Louis Vuitton design on a handbag, that would qualify for a design patent. So it's often used in the fashion industry, furniture that's it has a design to it, could potentially seek a design patent. Plant patents are for plants that asexually reproduce and only protect the progeny of that reproduction. So they're very narrow in scope. Within the last week, or I think around 9/10/2019, there was a plant patent granted in the United States for a hemp plant that is owned by the people who made Charlotte's Web. So it's a high CBD producing, low THC. The THC content, I believe, is under 0.3%, with CBD being much higher than that. And that's groundbreaking. To me, that's showing that the USPTO is becoming more accepting of registrations for cannabis. But so this is an area that I think is about to explode for the cannabis industry. So I used some examples of different patents that can already be found in the cannabis industry. The first patent is owned by GW Pharma, which GW Pharma owns quite a number of patents that relate to cannabis. And this is how cannabinoids can be used in assistance for treating cancer, which I'm all about. I think this is great that we're exploring the use for cannabis as it helps for medical issues, especially I think the research for cannabis and cancer. There's a lot of room in the future for this. The next patent is owned by Biotech Institute LLC. This was unique because it was, as far as I know, the first plant-related patent granted in the United States. Even though it was a utility patent that was granted, it wasn't a plant patent. But this patent was focused on a cannabis plant that had a high rate of myrcene, also had a high level of CBD in it. If you pull up this patent, and all these patents that I'm showing you should be accessible from the public. So if you want to do research, or if you're into science, these are some fascinating things to review. But this patent really broke down the different cannabinoid profile of the plant, and anything that was outside of the scope of that plant would not be covered by the patent. But it was still actually pretty broad, so I'm curious to how enforceable this patent will be. This is a patent that has a really unique history in the United States. It's pretty old. It was published in 2003. It was originally filed in 1999, and it was filed by, I think, the Department of Health owns it. But the reason cannabis has a Schedule 1 status in the United States is because one of the aspects of that is that it has no medical purpose. There's no medical benefit of cannabis. And this patent shows that a federal agency owns a patent and was granted by another federal agency, the USPTO is a federal agency or federal office, that cannabinoids do function as antioxidants and neuroprotectants. The reason that the patent was granted is because the claim was made that only synthetic cannabinoids have medicinal value. But I think this patent will come up years from now and will be used as a illustration of how times were going to change, and there was an awareness that cannabis was medicine well before it was accepted as medicine. We have our first patent infringement claim going on in the United States, which I don't think it's been resolved yet, but it's showing that courts, even though there is a Schedule 1 status of cannabis in the United States, courts are still open to hearing patent infringement claims as they relate to cannabis, which patents do not exist at the state level for litigation. They have to be federally litigated. So that's kind of fascinating. The registration for cannabis patents is increasing. When I searched on 9/14/2019, there were currently 3,216 patents that were written in English that used the word cannabis on the front page of the application. Leading this, interestingly enough, the country that leads in patent filings is actually China with 1,691. The United States had 594 and Mexico had 60. The most recently filed patent in Mexico dealt with the use of cannabinoids as a sleep aid. But patents in Mexico are also handled by the Institute of Industrial Property, the IMPI. Patents in Mexico must be filed in Spanish. They can be filed in English, but they will be a requirement to translate into Spanish if they're going to be registered. Patents are valid for 20 years in Mexico, and it takes on average of up to 4 years from the time of filing to have the actual patent right granted in Mexico. This is something where if you're working on an invention, I strongly recommend you to work with an attorney. I actually don't file patents. That's a whole separate practice of law than what I do. But from as much as I do have to deal with them when clients want to file them, from what I've come to realize, unless you're working with an attorney who is very knowledgeable on the subject matter, there's a lot of room to mess this up and mess up the filing, I should say. And if that filing, if there's an error in it, you might be waiting years to figure out if it's actually an enforceable patent. So it's something that really needs to be done right the first time. The last type of intellectual property we're going to talk about is appellations of origin, which that is a good or product that has such a unique characteristic that's tied to its place of creation that this region, this area is just known for making this kind of product. Recently, when California legalized cannabis for adult use, it had a standard in it that allowed for appellation of origin for cannabis areas to be created. This is very unique in the United States because the United States is not a signatory to the Lisbon Treaty for Appellation of Origin, which Mexico is. Appellations of origin in the United States traditionally have only been used in relation to viticulture or for wine. So by California allowing this, they're kind of breaking the mold for the United States in allowing for appellations of origin for cannabis to be created. This is being done by the CDFA, or California Department of Food and Agriculture. It's so fresh and in process that the regulations for this haven't actually been released, It's anticipated that closer to the end of 2019, there's going to be some form of regulations released. The CDFA has to start accepting applications for appellation of origin for cannabis by January 1st, 2021. So it's kind of pressing and timely. There's a group called the Mendocino Appellation of Origin Project, and these are some different regions that were proposed as potential appellations of origin. These are not created yet. These have not been filed. This is just aspirationally some ideas of how this might look. I searched for cannabis and appellation of origin on the WIPO, or World Intellectual Property Organization, appellation of origin database, and the last I saw, there was no international identification for cannabis appellations. So what California is doing will be the first in the world to grant protection for appellation of origin for cannabis. Appellations of origin in Mexico are very much a thing, especially because Mexico is a treaty or a signatory to the Lisbon Treaty. So from my research, I was able to find that there are 23 appellations of origin that are directly from Mexico, with arguably the most internationally recognized being tequila. But there are also 1,288 foreign registered appellations of origin that are acknowledged by Mexico. Recording an appellation of origin in Mexico is through the Mexican Industrial Property Law, MIPL. If there are areas in Mexico that are famous for cannabis production, what farmers in those areas might do is get together to petition the government to try and form an appellation of origin. What this would do is give a benefit to cannabis farmers in that region, that there would be a name associated with the quality and standards that have traditionally been used in that region for cannabis production. This will assist small farmers both on the international market, and it will kind of make a name for that region. So products that are created there will arguably be able to fetch a higher dollar value at market. So that was my presentation. I hope everyone has learned something, and I will now make myself available for questions. If you have a separate question, you can email me at lzimmerman@cannabislaw.law. Thank you for attending this, and I hope you guys are enjoying the conference.
Hi, Luke. Can you hear me?
I can hear you now. Can you hear me?
Oh, yes, I can hear you. Thank you so much for joining us today. Thank you so much for your presentation. We have a couple questions here for you if you're ready to be on the spot and take some questions.
I am. Are they actually the questions that were asked during the course of the lecture?
Yep, exactly. I have
Perfect.
5 questions for you.
Okay. Also, if you miss what I'm saying right now, I did respond in the comment section as the questions were posted.
Oh, perfect. Great. Okay.
Hit me.
Okay, so the first question is, if I'm using the WIPO database, can I search and see what has already been filed in my own country, or can I just see how many have been filed?
Mexico is part of WIPO, so you should be able to see everything that has been filed, searching through both name, description of goods and services. It should give you information about the owner of the trademark application. You can also do this for patents. So yeah, you can do a lot of research through the WIPO brand database.
Wow, you can get a lot of information there. That's good to know. Okay, so our second question is, what if I have a brand that is the same as a US trademark already?
Trademarks are granted only for protection in the country that they're registered. So if you had a competing brand in Mexico and it has not been registered by a US company yet, arguably you could use that mark in Mexico. Your you would not be able to expand into the United States. And if there is some confusion in marketing, that could cause some legal issues down the road. But at least for the initial outset, you probably could use that mark without having a conflict.
Okay, that's good to know. So we could register it in Mexico, for example, if it hasn't been registered yet in Mexico.
That is true.
Awesome. Thank you. Okay, so your third question is, how far in my business plan process should I be thinking about trademarking my brand?
Great question. I have to deal with this a lot, actually. In a perfect world, I have clients come to me where they already have their business model set up, but they have not necessarily picked a name to use or a trademark to use. And the reason why this is important is because if you pick a mark that has a possible conflict or it already has been registered, I've seen companies that are 1.5 to 2 years into operation and then have to change the name or change the use of the trademark due to conflict issues. So I think the sooner the better to consider trademarks, but also really you want to have your foundation for your business in place first, because when you go to register the trademark, you're going to need to register it to your business.
Okay, perfect. Thank you. Okay, so your next question is, if I have been using my trademark for a long time, but it hasn't, if I have been using my brand for a long time, but it hasn't been trademarked, do I have any rights because I have a history of branding, sales, and more with this brand? Or can anyone use it just because it wasn't registered?
You should have limited rights. I believe Mexico has the concept of common law right. In the United States, that would give you right to continue using the trademark in the region that you've been using the mark, but it would restrict your ability to expand. And if someone registered at the federal level prior to your registration, they could restrict the growth of your business, and they would be able to use the mark in other areas where you've not been operating. I'm not sure if that is exactly the same for Mexico. That's definitely something to speak with an attorney about, but I have a feeling it would be a similar concept.
Okay, that makes sense. And your final question is, if I am researching something, so if I'm in the research process, when should I start the patent process?
Patent process, once again, the patent laws in Mexico are probably a little bit different than the United States, but if you are working on a patent in the United States, you should be speaking with an attorney as soon as possible, because you want to do a patent clearance search oftentimes to make sure that there's not already a pre-existing patent. And then before you're really sharing information or putting the good or using the method in commerce, you want to have some form of protection filed prior to that. In the United States, there are some timeline issues. And to be fair, I don't fully work in patents. I just know a quick overview of them. And when I have patent work, I refer it to another attorney. But I know that if you disclose some of the information in the patent, you have a timeline of 1 year in order to have the registration filed. And if you go past that 1 year mark, you might not qualify for patent protection. So if this is something you're working on, you should be working with an attorney who has a solid knowledge base of the Mexican patent system.
Okay. So it sounds like we should be working with our lawyers and using the experts to help us through this process.
And that, I can't stress that enough. In the United States right now, finding good working relationships with attorneys is essential in the cannabis industry. And oftentimes the businesses that I'm seeing that are having some success, they don't just work with one attorney, they have a team of attorneys or they have a law firm behind them. Finding attorneys who also have an understanding of the cannabis industry has been invaluable in the United States, because there are some attorneys who don't have a knowledge base of what's going on in the industry, so they can't really give the best legal advice. I imagine it's probably going to be very similar in Mexico.
Yeah, I think that's true too. There's a lot of nuances that you need to be aware of that are specific to the industry.
The way I refer to it is 95% of it is exactly the same. It's the practice of law, it's in a similar space, but it's that 5% that really allows you to stand out and focus on what is going on in the cannabis space.
Sure, completely understand. Well, thank you so much, Luke. That was our last question. There really is a lot to think about and be conscious of when growing a business. So I really appreciate that.